we'll start. Okay, thanks. Let's all the participants and mute them. Thanks. Hello, everyone. Welcome to our talk this morning, afternoon. Ed, if you can just advise everyone to mute their videos and their microphones because it's going to interfere with the talk. Then we can start the recording. Okay, cool. So there's a lot of us online. We don't want to actually interfere with it. Okay, the talk today is going to be quite intense. As you can see, it's legal and compliance, and there's a lot of things as a director of a company. We're all eager to start a company and become a director, have a business card, and be like, nice. But there's a lot of things we've got to think about. So that job is intense. All right, so it's quite important to understand the rules around that. We want to avoid jail time, all of us. Okay, that's me, but now you guys have already seen that slide a lot. Probably the one slide that stays the same, so we won't waste any time on that. Cool. So we'll just go through some legal jargon, recapping some of the stuff we have spoken about in the past, and then onto the actual and directors and responsibility. So it's quite intense. So stop me, ask things. But we are actually and recording this. It will be on our website in about a week. So you can go to our website and watch the video again. Okay. A lot of the text on the slides I'm not going to just read through. We can discuss the highlights because otherwise we'll be here till 4 o'clock this afternoon. And I think Katie has a plane to catch. So although he wants to stay here this evening again, I think it's appropriate he goes back to work. Sure. All right, so these are the basic elements. I am going to step aside so you guys can see. So why do you want to actually have everything in order? Why should all your legal stuff be in order? So obviously it helps you with funding and growth. Can you get funding? Can you grow? Making sure your documentation is placed. SIPC, you've seen, I'm sure some of you have experienced SIPC doing like an actual deregistration of your company because you haven't filed your annual and returns. Very important. all your meetings you have. I know a lot of us are one-man band operations, so meetings are in between me and myself and I. But if you get yourself into the habit when you have a meeting, just and record the actual meeting, what it is, and it's just yourself. You might be thinking, what is my strategy for clients or for funding? Just note them down, and that gets you in the habit that when you do have like other shareholders, other and directors of your company, you're in that habit of obviously writing this stuff down. Who's going to do what by when? So your little list that you track, that becomes your minutes of your meeting in the future. Okay. Things like share certificates we've been through, quite important to have those. When you register a company at SIPC, you guys have heard us say this, SIPC only gives you your actual company. There's a whole section after that, which is post-secretarial stuff. That's your inaugural minutes, that's your share certificate, that's your resolutions, that's who's in charge of the company. That you have to do after the fact. And very often, no one actually does that because they don't know. And SIPC is not actually just telling you that. All right, so those actual elements. Closed corporations also have inaugural minutes. A lot of people think they don't. Although you can't register new ones, if you have a CC, you still have to have a share certificate, resolutions, meetings, things like that. Okay. And then obviously, nice to have a data vault. That's where you keep all your stuff. Your company documents, your tax clearance, your BE certificate, your shares, any resolutions you've done, you put inside your data vault. So if anyone, a funder, you want to do an application for a vendor list, then you can give someone access into your data vault because everything is there. Much easier instead of scrambling around. Where did I put this? And which file? Is it on email? Set that up. Much easier. All right. Cool. Questions at this point? Everyone good at this point? Anyone online? All righty. Yeah. Smart. Okay. So let's understand a few of the important points. Shareholders agreement. So that sort of gives you an idea who owns the company. If it's just you on your own, obviously that's fine. It does mitigate a few things around board meetings, resolutions if it's just you. But ultimately, if you've got a partner, this is where everything fits in. So you must have a shareholders agreement. If there's two or more of you, definitely do this. It outlines roles and responsibilities, as you can see, who's doing what, how they can sell their shares, who buys the shares, what happens if you die, what happens if they steal from you. All this stuff is, and you can actually have it inside there. All right. MOR talks to your shareholders agreement. You guys will know if you're registered at SIPC, you got your CR 15.1. That's your MOR. You'll see on there. So you don't have to have that small little MOR of 4 or 5 pages. If your shareholders agreement is quite lengthy, you can put that information into your actual MOR. So those two documents actually speak to and each other. Okay. Trademarks. We have touched on this in, I think our first talk maybe. Quite important to have, and trademarks are, you can register obviously at SIPC. You register your trademark. Specifically, if you have a logo or a brand that you want to obviously look after, like the Shark's logo, as you can see here, that has evolved. The original Shark looked a bit softer than this one, but they trademarked them, so no one can go and copy it and do that. So if you've got a specific brand and you know you're going to be growing fast, especially getting lots of funding, go for a trademark so no one else can obviously copy it. And that's, again, one of those sort of legal documents stored inside your vault. So if somebody does use your trademark, you've got the stuff to back it up. Send them a lawyer's letter and so on and so forth. Okay. Patents, we touched on again as well. So just be careful with patents. We did say often there's patent fees at the patent offices around the world, and as you're lodging your patents, they're having a look at it. and they're manufacturing your product in China before you even got your patent. So often what's happening is with patents now is they're leaving small little key parts out, like the integral thing, like if you manufacture a gun, you leave out the firing pin. So if someone tries to copy it, it won't work. So those small things are being left out purposely because of these patent thieves. So just be aware of those things. So unless it's something really special that you've made, like most of the clients nowadays aren't even patenting. Or they're doing what like Elon Musk and them are doing. They'll actually patent a product and then open source it, put it on their website, all the details, all the plans, so everyone has access to it. So it just varies on how it works. Okay. Tax numbers, obviously, we get a tax number. We get, obviously, as you all know, as you actually register your actual company at SME. But if you don't have a company and you're trading out of a trust, or you yourself want to just be a sole prop, you physically have to go online, register the income tax number. You won't actually like just arrive automatically as it does, you know, when you actually register a company. So just be aware of that if you're a sole prop, or if you've got a trust or an NPO, those things, then you have to actually go online and do it. The other things, obviously, touching on UIF, minute you employ somebody 21 hours a month or more, you have to register for UIF. And then SDL comes when your payroll is 500,000 Rand a year or more. Okay. We've been through a lot of those annual returns at SIPC, BE. These are things you need to keep inside your data vault, because someone's going to ask you for it. When you get onto a vendor list, you want to make an application for funding, they're going to check all this stuff. This is the box-ticking exercise. I'm sure all of you guys have been through this when you've gone and applied for funding, applied to be on an ED program or on a vendor list at a corporate. They're asking for all of these things. All right, so just make sure that you have them. If they don't apply to you, at least know when you need to do it. So it's actually important to know that. That's obviously pain in the neck for everyone, because SARS wants their money yesterday, but only wants to pay you in 3 weeks' time. So make sure when you do that, it's accurate. So, question?
I can talk here because I can't hear. We have a question from Mark. Do you have to have the trademark valued each year? Who does it, and where does this valuation get recorded in your data vault?
Okay, Mark, thank you. Trademarks, there's two ways to value it. And generally what it is, it's come from the cost, first of all. So there's a cost to manufacture the product, to that trademark. So it has a value based on the value of your company. So let's look at like someone like Coca-Cola, for example. Because of the value of their company and the recognition of that brand, the trademark value is higher, and that generally is normally a discounted value on your company valuation. And these things will change. So how much is something worth? What somebody else will actually pay for it. So what you find is, because it's an intrinsic value, a lot of companies don't want to revalue it on their balance sheets, often because if the intrinsic value of your asset goes up, the taxman wants some of that. So you'll sort of generally raise it in line when you've got tax losses or something to take into account for it. So you'll raise the value of the trademark, so you're not actually paying tax. But ultimately, the true actual value is when somebody buys it from you. So if you want to sell just the Coca-Cola brand and not the whole plant, the bottling plants and stuff like that, which in this case is owned in a separate entity, you can buy just the logo, the Coca-Cola logo. Okay, and that'll be the value, whatever they pay. So Mark, hopefully that answers what you're asking. Okay. Okay, now we're going to get into the technical stuff. This is what the talk's really about. You guys have been through all those other sort of need to have things in terms of your business. Now you have your business. And what does it mean? So the Companies Act sort of drives how a company gets run, what the rules around owning a company, running a company, setting up a company, all that type of stuff. The Companies Act we have now, 2008, Companies Act of 2000, is the third one in our actual country's history. The first one was, I think 1903, Companies Act of 1903. Then we had the Companies Act of 1971, and this one, the Companies Act of 2008. So they don't change often. And normally when they change them, the idea is to change them to make life easier, make life of the SME in this case it was for SMEs. It was to make SMEs' lives easier because they were phasing out the closed corporations and making the rules around owning a company easier. Okay, so that's why the change happened in SA. So, it's fighting with me now. Okay, so these are the objectives. Okay, as I was saying, I don't want to read all the text off there, but essentially make life simpler. So a lot of the legislative jargon was taken out. So they changed the legislation to almost be sort of good conversation with the legislation. So if you ever, just out of interest, has anyone even looked at the Companies Act? No? Okay, and good, good. Anyone else online? Yeah, exactly. So probably of the 100 people taking part in this talk, one person and myself. Yeah, it's not exactly something you want to read at night if you like bored, because you're going to fall asleep. So they've changed the act so that it's not legalese. You're not like having all this lawyer talk. It's normal English, simple English, so that everyone could understand it. And that was the key. Simplified it, accessible language, things like that. And then obviously to take away the chances of getting to jail. Because the old acts were very much a case of, if you do this wrong, there's a massive penalty. And the penalty invariably is a big fine or jail. Okay, so they realized running a business, not everyone's crooks. Because crooks really don't care about the law. Because if they did, they wouldn't be crooks to start with. So they realized not everyone's crooks. So just take all that sort of legal stuff out where the chances of prosecution are fairly low unless you are a crook, like fraud or embezzlement or things like that. All right, so because, I mean, there's no point. What you're doing is you're keeping honest people out of the actual process. Okay, so that sort of gives you an idea. Okay, what were the major changes? So the big headache around the companies is, when do you meet? What do you do? How do you give instruction? Because a lot of, and it's especially for the smaller company owners where we are, and this is where they changed the law, because a lot of the law was thinking about large companies like you see on the actual JSE, on the actual stock exchanges, where there's multiple shareholders, you're not really involved in the operation of the company, they've got separate boards, and those boards, the boards aren't really shareholders. So there's a lot of sort of separation in the roles. But as smaller company owners like we are, you're all three of those things, probably. You're the shareholder, you're the employee in the company doing all the work, and you're on the board. And all of that morphs into one little thing where you think that's all the same thing. But they're separate roles, distinctly, and they've changed it so that you understand those roles, what the rules are around each of those roles. So it's actually important to understand that. Because too often it's just like, oh, it's my thing, I can do what I like. No, you can't. As an employee, you can be fired. As a director, you can go to jail. As a shareholder, you can lose all your money. So just be aware of those things. So these are the changes they've actually brought in. Yeah. So all your meetings and stuff like that you can do by, they've learned about tech, because back in 1971, there wasn't a cell phone. I was only a little baby then, so there was no internet. all those type of things. So they've updated according to tech, so people can do online meetings. They obviously knew that COVID was on its way, so they planned in advance. So you can do all things. So you can have a proxy. So what a proxy is, just so you know, so if you're a shareholder and you can't be at meetings, you can give somebody else your right to vote, like a proxy. They stand in your stead, so they can attend the meetings and they will speak as if they're you. Okay, so that's what a actual proxy is. So now you don't have to be there personally. Okay, meetings can be done electronically. In the act they mentioned Skype, but obviously things have moved on from there. There's Zoom, there's Teams, things like that. So meetings can happen all the time. So I'm fighting with the clicker for some reason. They've changed when the notice periods have to happen. They've shortened them, in fact. So 15 days for a company, like a company on the actual JSE, a public company where you can trade shares. And then obviously a private company is what we mostly own, only 10 days. So that shortens the cycle down a lot. You don't have to wait 30 days to have a meeting, notify everyone and things like that. Okay. Shareholders meetings, they've brought in thresholds which weren't really codified in the earlier act. So special resolution is if you want to sell the bulk of the shares, or there's something major, you want to change the focus of the company. So it requires all the shareholders to be involved. And then they've set this, like the actual threshold, 75% of the shares. Ordinary votes, ordinary resolutions, adopting your budget, maybe a staff employee plan, ordinary stuff. Only 51% of the shareholders have to vote on it. Okay, so there is that change. One is a big change where everyone has to take part. The rest is just operational changes. There's nothing major. So as long as half the team are on board, then it works. Okay. The Memorandum of Incorporation, so that's that CR 15.1. You can lower these, as it says there. So you can lower it down, but it can't be lower than 10 percentage points either way. So you could make it stricter. You could make it 85%. Or 61. So you can see, so it gives you space to move around, but then you have to put it into an MRR. That's what drives the actual operation of the company. Okay. The duties of the directors. Okay. Let's see. Okay. You've got two items around that. Okay. So firstly, they've actually codified all your tasks, essentially. Not into the finer detail. Okay. And they keep it in the common law, so obviously you can't go and have a second company trading against this one and so on and so forth. And then it sort of codifies what you can actually prosecute it for. You know, when are you going to go to jail? You know, what have you done wrong? Because if you embezzle money out of the company, there's got to be a role where what you'll actually end up going to jail for and stuff like that. Like Steinhoff, perfect example for lots of things. They were clearly doing fraudulent stuff. They were inflating the value of the company, and what they were using there, they were then using those inflated shares to get loans, and then using those loans in their private. It's like, oh, Joost went and bought a stud farm for a couple of hundred million rand on the value of his inflated Steinhoff shares. And he bought the stud farm cash. When the shares crashed, he still owns the stud farm because he bought it cash. You see, so that's obviously against the law. So those are the type of things. Okay. Yeah, quite important. This hasn't really been used. I find it so strange. So CRPC, technically, I don't know why they haven't done it, but CRPC can send out notices. Like if you don't do your annual returns, they technically should send out a notice to the company to do it, comply with the notice and things like that. But they haven't really done so. but effectively they should be able to do this. So there are a whole section around what will happen to you if you don't actually do these things. So let's just, okay. So if you don't comply with the Companies Act, you get fined and possibly jail time. I mean, so they can even ask you to wind up your company because you clearly not trading ethically. You may be setting up a pyramid scheme. It looks nice on paper. If they find out that it's obviously just a scheme, they can close it down. You'll be prosecuted and you can head off to jail or actually pay a fine. So, yeah. But they don't really use it, which is strange. They should actually be doing it a lot more. Okay. Questions at this point? Anyone? Kuleleka?
Thank you. I just have a comment. We take the responsibilities of the director very lightly because it's just a piece of paper. But this is the more serious stuff, you know. First and foremost, the first comment is the tax avoidance. One guy, a couple of months back, we've been doing it and it's been successful, avoiding SARS. But 17 years later, they came knocking and they took everything, you know. So whether you're successful in avoiding tax the wrong way, we all want to avoid tax, but the right way. Yeah. Evasion. Yeah, no, correct English. But another thing to emphasize the responsibility of the director. So because technically it might not drive home. Two guys own a company in Limpopo, a construction company. They were digging a hole. The other director is never there. Doesn't focus on the runnings of the company. He's just there because of the money. So the other guy is digging holes. A safety officer should have been on site. They never paid for the safety officer. Once you dig a hole a couple of meters, you need to make sure that there are piles so the soil won't fall in. The soil fell in, 4 guys died. So 2 guys went to court for culpable homicide. As I speak now, they both in jail. But the other guy's defense is, I didn't know. But just because it's on that piece of paper, he signed that piece of paper, today he's in jail. Thank you.
Thank you. Yes, and that's actually quite important. We're going to get to that in this actual session coming forward. So, and directors run the company. They're responsible for what's going on the day-to-day running. The shareholders instruct them, giving them instructions on how to run the company. So this is why it actually separates out. So, but the nice thing is, in this case, if that other director did not know, like if they had a board meeting and said, you will go and hire a safety officer, we have a procedure in place, everything like that, and then pass the onerous task on to one of the other directors, because they weren't going to be there. You will ensure the following, we have a procedure, so on and so forth. They wouldn't be in jail now. You see, so it's important. So that's part of those roles. So Ken, you had a question?
Yes, again from Mark, it basically ties into this. How painful it can be to bring minority shareholders into the small business. Everyone likes the ideas of going into business with a friend, and a 50-50 split or a 75-25 split is general, but planning for a divorce is important. What can you suggest there?
Thanks, Mark. So just to backtrack from the beginning of the slides, that's where your shareholders agreement comes into place. That codifies what happens. Because what you want to do is, we all know when we meet someone, when you're first in love, going on a date, anything's possible. You'll give them anything, give them the world. What happens when you split up? So think about that at the beginning. You code that into your shareholders agreement. If your shareholders agreement is in line with the actual Companies Act, then you don't have to change your MOR. If your shareholders agreement has got things slightly different, so think about like an employment contract, if you're a staff member, and the actual basic and Conditions of Employment Act. As an employer, I can give my employees anything above the basic conditions of employment. I can say you can have 6 months leave. But I can't say you can only have 10 months, 10 days leave, because the Act says 15 days. So it's the same with the Companies Act. Your shareholders agreement can give more, way more rights, but I can't take rights away. All right, so your shareholders agreement drives that, Mark. So and then from there, it takes what happens if your partner doesn't sign the resolutions, doesn't come to the board meetings, won't go to site and work, won't contribute funding. The shareholders agreement speaks to that and how those shares will be sold, how they'll be bought back in the company. And as long as then if it's different to what the Companies Act is, you then codify it into your MOR. And that MOR gets lodged at SIPC. No one can argue. It becomes part of the sort of legal system as such. Okay, Mark, hopefully that answers that. Anyone else? Questions on that? Cool. What have you done with my clicker?
Yep, we've learned the hard way around minority arrangements.
Okay. Okay, how can you now hold your board meetings? It's quite important because back in the day, everyone had to be in the same space. Regardless of where you are in the world, you either flew in to the meeting or you had a proxy. Remember we spoke about proxies in the earlier slide. So you can have a proxy in the place to be there. So everyone had to be there physically. Okay. So there we go. So now you can actually have them electronically. I don't know anyone who uses Skype anymore, but you can do Zoom, Teams, pretty much any online system. Okay, that goes for so. But the same sort of notices apply. You still have to do the legal part behind it. Send out the notice in time so everyone knows to attend, things like that. You can make the notices longer, but you can't make it shorter. Unless, again, you agree in your shareholders agreement. Then you can sort of, depending on the actual, nature of the meeting. Okay, so this is important. You can do what? We did touch on this earlier. Okay, special resolutions, big things. These are big things. You, a construction company, and now you're going into retail. That's a big change. It's going to require a whole lot of investment. 75% of the shareholders must actually apply. Okay, ordinary stuff. You want to give the CEO a new increase or buy a new car, then just most of them have to be there. Okay. Yeah, this is important. What can you be held liable for? Liable means a fine or jail, or being fired. Okay. Fiduciary breach, which means you're not doing your job according to the Act. Okay. Acting without authority. So if the shareholders have told the board they can't do a certain thing, like, for example, they can't sign off the CEO's increase without the shareholders' approval, and the board does it anyway, they're in breach. You see, so I know it seems weird because we're all smaller firms, so we're all three of those roles. But where you have a partner, it makes a lot of sense. And obviously, false information, misleading information, and that can be to the shareholders or to the clients or even the staff about the nature of the business, what it's doing, and stuff like that. If it's going to implode, you want to know it's stuck in advance. Okay. Okay, just to compliance. So obviously, SIPC can take issue. They'll send you notifications. If you don't follow through, big fines, jails, 10 years. It's codified in there. If you've broken the Act, they've already said that's your minimum sentence, 10 years. Okay. But it's very rare that it's happened. I think the only one that's really come through is, I think Menu. She was a minister at SAA. I think she's the only one who's actually been prosecuted on this. Although she hasn't done jail yet. I think she's the only one, actually. Dudu Menu. I think she's the only one. They're probably going to prosecute Jooste on this as well. So it's very, very important. Okay, what's your roles and responsibilities? Okay. I'm not going to go read through all that. You guys can read it online. We'll share the slide deck with you guys. Okay. So, you must know your rights. So there's another side that details a lot of things. So, know your and responsibilities. Ensure that you understand the MOR, that you're actually following it. It's important to actually follow the MOR. A lot of you probably never even read your CR 15.1, that you got from SIPC. I suggest you all go home this afternoon and read it. Seriously. It's not long. It's about 6 pages. It'll be the standard one, 6.1A. But it's important. Just read it and understand it. If you've got any questions once you've read it, send us an email. We can help you. Okay. I'll just dig into this. So here's duties, responsibilities, and rights. I'm just going to do the other one as well so you can see them both. Okay. So this is what you should be thinking about. Okay. And a lot of the stuff for smaller companies, we don't apply. But when you're bringing on a partner, so when you're actually bringing on a partner, or if you, and I think it's quite important, I'm going to raise this point now, but it's quite important. A lot of you might not necessarily want to bring other board members on now because you think you're going to pay like a board member salaries and stuff like that. But something to think of, and we try to advise our clients, but in this center where you guys are, there's a huge sort of range of skills that you guys can actually utilize from each other and share that information, share what's inside your head. So you can create what's like an informal board. You don't necessarily have to appoint someone to your board. But chat amongst yourself and see what skills. I'm good at sales and marketing, Ken's good at operations, KG's great at tax. All those skills are really cool to have inside your company. But yes, I can't afford to pay them. They pay me. But yeah, so chat to someone and go, let's form an informal board. You don't appoint them to your company, but then follow these processes. Have a board meeting. Talk to them. What is your input? What be the responsibility? And you guys will actually benefit enormously from that. Enormously. Because you're sharing that information, sharing sort of ideas, and then running through the processes. So when you do grow, a lot of the stuff is already ingrained in your operation. It's ingrained in your thinking. Okay, so, and you can see, I mean, look at these things. And a lot of it's sort of common sense. You're going to act in good faith. Like, I'm not going to have a meeting with you and then go run up to your client and steal your client. That isn't actually good faith. Okay, different things like what you're pointing, the structure of the board, who's doing what. So like codify roles and responsibilities, and it's a good exercise to do. Because I know none of us start a company to remain a one-man band. Our goal is to grow. We want to be the next Coca-Cola, the next Tesla, whatever. So start with these actual things. Okay, so there's a lot of stuff to go through, and you won't necessarily need a lot of them. Like company secretaries, for example. A company secretary deals with SIPC. So a company secretary will do the resolution. So first of all, they'll send out the actual notice. When is the meeting happening? Make sure all the directors have the notice. They will then sit in the meeting. They'll write up all the minutes of the meeting, the resolutions of the meeting. They'll then update the share certificates. So it has to go to SIPC. They'll send it off to SIPC. So that's what the company secretary does. In a smaller company, you don't need to hire someone permanently. It's a role that we do. So your accountant should know how to do it, generally. A lot of them don't know because it's quite a specialized skill. But get into the habit of it. Duty to keep accounting information. Even if you're a one-man band, you have records of your books. It's a requirement in not only the Income Tax Act, but the Companies Act. And the record doesn't have to be pastel, Xero, QuickBooks. It can be Excel. It can be a piece of paper. As long as you can record your information, that's keeping record. Okay. So as you can see, there's quite a lot of these things. Read through them. It's brand new. It's killing me now. Okay. Number of them and directors. A lot of us around here are just the one. That's the absolute minimum. Okay, you can have any number above that, but minimally one. A non-profit, 3. And the reason why, obviously, because of a non-profit, you're running with other people's money. So they want 3 people who are not family. So that's important. So the idea is that because they're not family, they'll keep each other in check because they're spending other people's money. Okay. You don't, like, how do you get rich? Other people's money. No, that's not what you do as a non-profit. Okay. Removal. So with the one-man band, it's obviously a bit easier. You can't remove yourself. But generally, if there's multiple shareholders, you'll generally have multiple and directors. So how do you get them off? And with your roles and responsibilities, your MRR that speaks to these things, if they're not doing their job, remember, actual and director is a member of staff. So they can be disciplined for not arriving at board meetings, not doing their job. What is their role? So think of them, they work for the company. Okay, so they'll have a disciplinary hearing, you can be fired, the shareholders can vote them out. They can obviously apply for things. So just think of them as staff. And generally the same reasons that will get a staff member fired will be normally the same stuff that will get a director fired. Okay. Unlike the US, where if you arrive at work and the boss doesn't like your shirt, they just like, think's not my color, cheers, and they can fire you immediately. There's no like sort of labor law and stuff like that as much as they say. So we've got a bit more things to do here. So a board meeting. Okay. Any of the directors can actually ask to have a board meeting. And of course, you don't have meetings just for the sake of having meetings. A meeting is to accomplish something. So there's got to be a reason what it is. And there must be at least a quarter of the other directors there. Okay. You've got to keep minutes of all the meetings. So just get in the habit. Even if you have a client meeting, start just making notes of what that is. It'll get you in the habit because it's a good thing to have, especially to refer back to later. Okay. And directors generally have one vote. Normally in the shareholders agreement, the chairman, there will always be a chairman of the board, and that person will have the overriding vote. Okay, so if there's even numbers, but normally you have a board with an odd number. But if there's an even number, the chairman has the overriding vote. So 6-6, I'm the chairman, I'll make the overriding vote. So it'll be 7-6. Okay. Things like this. Again, you don't have to all be in the same place. You can email the agreements from and director, they'll sign, email it back, send it to the next person, they'll sign, send it back, and that's how you do it. That's KG is going through it right now. There's no special process, as KG explained to a client last night. Just sign it, send it to the next person, let them sign it. Liability. What happens if you don't follow the rules? So, a director is actually, the Companies Act is anyone in a sort of, prescribed officers fall under that as well. And a prescribed officer is anyone who holds a leadership role that can represent the company. So you don't have to sit on the board at all. But if you're someone who can represent the company, you can be held liable under the Act. So quite important to know. Like things like CEOs, MDs, CFOs, those are not real actual titles. The US came up with those to circumvent the Companies Act in a way, because a CEO is just a chief executive officer. What does that mean? They hand out titles instead of increases, I think. So they want to get around it. So if you can't, like in the US, trying to think what the body's called now, offhand. But effectively, they can decide, like our SIPC, if you done something wrong, you can't be on the board anymore. So what they did in the US, they created a title like a CEO. So I'm not on the board. I'm not, the board technically is my boss, but I actually run the company. You know, I think the FAA. But anyway, yeah. So, the SEC, that's the Securities and Exchange. Thanks, Mark. So, and that's what happens. And they created those roles to get around it. So the acts have been amended to include, you know, prescribed officers. So that people can't actually evade the law, can't do bad things. All right. So things like liable for breach of your duties. So if you're not following what's in the act, you can be prosecuted. You obviously disclose your personal financial interests. You can't sort of insider trade. You can't use the information of your company to buy shares or sell shares. So those type of things. Yeah. You can't go hire your family, nepotism, things like, you know, just you've got to be thinking of the best interest of the company all the time. That's your role. And if you're not doing that, then you're in breach. Hold on. That's fine. I'll use the mic. It's fine. Cool.
No, but what if my family is the best person for the job? Then that means it's nepotism, or my family is the best person to employ.
Okay, so where you own all the shares and you are the both the shareholder and on the board, I don't think anyone will care. But if you a large organization with multiple shareholders, you've got to put that to the vote. So you'd say to the board, my family, my daughter, my son, my niece, my nephew, they're the best person. Look at their qualifications. And they might then interview. And what you then would do is you would step out of the interview process. And then if the board then agrees with you, they'll hire them. So you've got to take yourself out of that process and let them judge, not just on your word. You see, that's what happened at sign-off. They just trusted old Jooste. Everyone trusted him, and look what happened. Same thing. Okay, so just be aware of that. Shareholders can now sue the and director for losing money. It's important. Things like that. So, like in law, they use a thing called the reasonable man test. Really. So, what would the reasonable man do? So, based on all the information you on the board will have, what course of action is the reasonable man going to take? I mean, they use here the business judgment test, similar thing. And if you can show, based on the information you have, even if the company implodes afterwards, and they come and want to sue you, and you can show, but based on the information available to us, this was the best course of action, then it's fine. No one can sue you. Accidents happen. Information is that the way it is. But so that's why you've always got to be, gathering information, getting the right stuff, employing the right people to share the information with you. So the reasonable man test is quite a good thing in terms of how you're going to run your company. Important. How do you indemnify? Because obviously the companies can obviously indemnify. Because if you make the rules too strict, nobody wants to run the company. What's the point of that? You're never able to hire anyone. You're never able to afford them. Because who's going to want to work at a company where I'm going to get sued? Or I'm going to go to jail? So there's certain acts that the company can obviously indemnify you from. And they can buy insurance for those things. But those are like the reasonable ban test, for example. Oh, you made a bad call, and the shareholder starts to sue you. The company can take insurance to actually fight your court case because it was just one of those things happened. Who knew COVID was going to happen? So maybe just before COVID, I decided to expand the factory. And we spent hundreds of thousands of rands expanding the factory. COVID happened. That's it. The company closed now. The shareholders could sue and go, but why didn't you know? Who the hell knew? You see, so the company can actually indemnify you on that. So this is the kind of thing. So you can mitigate the different stuff. So you can just read through these. But quite important that the company and the shareholders can sue you as a director if you've done something wrong, like a criminal thing, not I made a bad call. If you made a bad call with all the information, if all the people decided, no, we mustn't go that route, and you said, we're doing it, I don't care, and it fails, then I can sue you, because now it's not reasonable. People have told you, don't actually do it. Okay, so just bear that in mind. Yeah, this is splitting your roles, because often you are both, the director and the shareholder. Okay? So, in simple terms, the directors own the company, the shareholders own the company, and the shareholders employ the board, the directors. Okay, and they then instruct them. So in your shareholders agreement, it'll specify when you can appoint a board member, when you fire a board member, and you'll generally try to codify the roles of certain people on the board. So obviously the board will then go into detail and employ either more actual board members or not. So have it in that sense. Shareholders employ the board. They are the shareholder staff. The board runs the company. The board employs the staff. You know, the normal employees, that's who the board. And then the board, once the shareholders have employed the board, they must get out the way. You can't sit there and instruct the board on a day-to-day basis with operations. Well, why did you hire this person? Why are you buying stock? Get out of the way. That's not your job. You've employed the board, leave them. Let them do their job. If they're not doing the job, fire them. See, so they want to separate those two roles. The board runs the company, employs the staff, decides the sales strategy, all of those type of things. You can make it in certain elements of your shareholders agreement and your MOR that if certain things, if the board's going to spend more than X of your income, it must go to a shareholder vote. So you can drive those things. But effectively, once you employ the board and you put the MOR, the actual MOR in place, get out the way. Let them do their job. It's like employing staff to sweep, and then you're standing there holding the broom, and you're pushing. You don't even push it like this. I mean, what's the point of having the staff? Just sweep the floor and yourself. So it's in that sense. Okay. Anything on that? Questions on that? No one? Is everyone asleep?
Yeah.
No, I warned you. This is technical stuff. This is really technical stuff. And you'll notice from some of the slides, we've actually repeated some of the stuff because I know we've done it on purpose because your mind starts running. Well, what are we talking about? It's quite technical. And you're going to miss the earlier slide, but you've now picked it up on the later slide. Or you got the first slide, you might have missed the second one. So a lot of that it is in here on purpose. Okay. Let's go see. What's the most important things? Okay, MOR, shareholders agreement. Those things are key. Okay? Read them, understand them. If you don't read them, don't understand them, you're going to pay the price, I promise you. And they don't have to be complicated. So these things you can, providing you don't in breach of the Companies Act, you can make it very, very simple. Okay. Executive and non-executive. Quite important. It doesn't really happen for smaller companies, but larger companies. You know, often you want somebody on the board just as a sounding board. They're not involved in any of the sort of operations and stuff like that. So that's what you normally have as a non-executive. They will just be there at the board meeting to actually listen. Maybe they're an industry expert. And when you're discussing your IT strategy, you invite them onto the board meeting because they'll have some insights that'll help, but they're not going to be involved in making the decisions to run the company and stuff. Okay. All right. So important to know. It ties into what we were saying a bit earlier about creating your own virtual board. You might decide to make it formal and invite them onto your board, but you invite them on as non-exec. That way they can't get into trouble either if they're helping you. Yeah. Who else can be held liable? As we touched on earlier, people who are in responsible roles. Okay, prescribed officers. All of these people, they might not be sitting on the board, but they're involved in making the calls in the company. They're involved in giving the board information so they can make calls on the company. So just be aware. Just be aware of who else is actually and accountable. Okay, control. Who's actually in charge? Okay. Who do you think? Who's in charge? Shareholders or the board? Yeah. It's shareholders. It's always the shareholders. Murphy's golden rule. He who holds the gold makes the rules. And that's the shareholder. They're the one funding the company. They're the one who, when the board runs into trouble, they need extra capital for something, or they need a loan, the person signing is the shareholder. Ultimately, it's always the shareholder. They set the rules. So remember, shareholder employs the board. The board employs the staff to run the company. Okay. You guys are both. In fact, we're all three. We're funding our companies. We're thinking about structure, where we're going to take our companies, and then we're working all day to do the job, to make that happen, until we can hire our first staff, and so on and so forth. Okay, but think about that now already in that cycle. Think of your different roles. They're slightly different. A lot of it overlaps, but it's slightly different. Okay. Cool.
Sorry.
Questions, yeah?
Yeah, another one from Mark. Can you hear me? Another one from Mark. At what point do you recommend a delegation of authority be put in place?
Mark, right at the start. It's the same as employing staff. When you employ staff, set the rules at the beginning, right at the beginning, and make them as hellishly tough as you can. And I'm not saying that because you want to be mean, but make them hellishly tough as possible right at the start. You can always not actually and apply them, or you can apply them to a certain level. But if you make them weak, you're never going to be able to apply them harder. You'll lose that fight every single day. So right at the beginning, make those rules as tough as you can possibly make them, as tough as the act will allow you to. And then you can use that. So if an employee is late once a day or once a week, he's 5 minutes, so what? But if someone's not arriving for work once a week, you want to know you can fire them immediately. And the same with your board. If they're not coming to the board meetings, if they're not giving you the information as a shareholder, you do that immediately. So make it tough, make it right at the start. Okay. Cool. Okay. Tips and parting thoughts. Your MR, your Bible. Read that. Go home tonight, all of you, and find your MR. If you can't find it, you can get it on your SIPSI website. Just go on, and you should be able to actually download it. If you can't, we do have a sample, Okay. We've got a sample we can share with you. Okay, it's the same standard. I guarantee you've all got the standard 15.1A. So we can share that with you. Okay. Management team. Currently, it's probably you. Okay. Ensure they're credible. Ensure they know what they're doing. If you need skills, upskill. If there's something you need to know, talk amongst yourself. Get friends in business. They can help you. They can guide you. Create your informal board. Okay. Compliance. We're going to hammer on compliance in every single talk. When you get to, by the end of the year, you guys are going to discuss seriously compliance. Look, we're going to make you check in the door on a B certificate and a tax clearance certificate and a no, but seriously, compliance is key. Keeping it up to date on a monthly basis. Most of them are monthly or annually. So pay as you earn, UIF, monthly, taxes, RP6s, like half year, the rest are annual. So not a lot. I mean, it's a lot, it's a pain in the neck, but just if you keep them up to date when they're supposed to be up to date, it's much easier than trying to fix 5 years. You know? So just keep it up to date. The no return, put it in. Don't go, it's no return, it's fine. But when you need a tender, now you need someone to do no return for you, Now SARS is offline because they can't, now you can't do your tender. Now you've lost the tender opportunity. Just do it. Put the no return on. Done. Okay, so compliance, keep it up to date. Alrighty, I think that's us. Anything else at this point? Questions? Anyone? I think I've scared everyone. I think they're all going to run back and read their MOI like, what have I got myself in for? How do I resign from my own company? Okay. So, excuse me?
I want to know, how do you sell shares of your company?
This is quite key. So if you have a private company, so PTY Ltd, private company, if you sell shares, you can't advertise your shares like you do on the JSE, like companies do. So you'll generally have interested parties. It'll be somebody who you know close to. You talk to someone and I know someone, they might be interested to buy in. And then the shares will depend on the value. Value is determined by two things. Mostly what other people think it's worth. That's the thing that actually and determines the value of your shares. What other people think it's worth. Doesn't matter how much the assets are. Doesn't matter what your turnover is. You can create a nice model, get someone to do a valuation of your company. The shares would be worth X. If I come along and I go, that's nice, that's pretty, yeah, the shares are worth X. I'll give you Y. You're either going to take the money because you need it to go to business, or you're going to wait for the next person. So ultimately, it'll be the person who decides, the buyer, will determine the value. But generally, what you'll then do is, let's say you find a buyer, you're both happy because obviously you've got to be a happy deal. Your shareholders agreement is now going to determine that. So your shares, most companies in SA, what we've seen, we register a lot of them, that you'll authorize 1,000 shares. You look at your 50 docs, your MRR, there's authorized shares of 1,000, but then you issue 100. So you'll issue 100 for your first share certificate, be it yours, but it doesn't have to be 100, but we just see that on average you issue 100, and that might be then split. So if there's 10 shareholders, they'll each get 10 to make up the 100. Or the one person might get 50 and the other 5, then there'll be 6 of you, the other 5 will get 10 shares each. That'll make up the 100, and that's 100% ownership of the share. The issued shares, the other 900 that you haven't issued, is like now someone wants to come buy shares. Your business is growing, you like buy some shoes, you're growing nicely, and you need funding. The other shareholders who own shares, 10 shares, 20 shares, can sell their shares because they want out, they're tired, or those 900. You generally issue further shares. So if that person wants to buy 50% of your company, you'll issue another 100 shares. So the difference between the two, if me as a shareholder sell my shares, I get the money. Me personally. It doesn't go to the company. It's mine, my shares. And most investors or most people buying into your company will want you to do a rights issue. So the company sells the shares. So of your 900 shares left that have been authorized, the company does a rights issue for 100 shares, which now brings you 200 shares into play, which is now 50%. They own 100 and the existing shareholders own 100. That money now is the company's money. And the company will then use that to buy stock or, purchase vehicles, whatever you need to do, whatever the company needs it for. Because the problem when you sell your shares, you just decide, no, I'm putting it in my pocket. I'm not going to put it, because then you would have to loan the company the money, and then the company owes it back to you. So simplify, selling the shares, as long as you've got your shareholders agreement, that's where you need a shareholders agreement, for what they're going to comply with, and they must see the shareholders agreement. If you don't have a shareholders agreement, use the MR. So they must know what their responsibilities and their roles are before you take their money. Because if you're struggling for money and I'm a dodgy oak, I can tell you right now, I'll own your company from you in no time, because if you don't have a shareholders agreement, I'll use your MRR, I'll buy half your company for whatever you want. I'll then say we need to put more money in to expand the company. I'll have a board meeting. You can't afford the shares, I'll do a rights issue for another 900 shares, and I'll own 90% of your company, you'll own nothing. So be careful of that. Okay. It doesn't happen often, but just be careful. All right, does that help? Anyone else? Anything online, guys?
A lot of thank yous.
A lot of thank yous. They're tired, they want to go now.
We've got something from Nkasi.
Okay.
Very informative. Presentation covered everything when there aren't many questions.
Okay. What do you want, Nkasi? Did my mom ask you to write that? Okay, everyone, thank you. We really appreciate your time. We'll give you guys a notice for next month's talk. We'll just check what it is and let you guys all know. But remember, if you can't attend in person, just let Mandy know and we'll sign you up online. Okay. And then you can, if you're sitting at home, you can watch on your phone, chat or your laptops and stuff like that. All right. Cool. Thank you. But please, if you think of something, send an email to us. We can help. Okay. Cool. Thank you. Thank you.
Cheers to Cheers to the online.
So the online people, we're also saying thank you. Enjoy. Thank you for your time. Cheers.
Thank you. Bye.
Thanks. Thanks, guys. Bye.